My name is Catherine Ellery. I am 51 years old. On March 14th, at 9:47 in the evening, my mother called me from my sister's kitchen and told me to sign a prepared statement accepting criminal responsibility for a vehicular hit and run I did not commit. The statement had already been typed. It was 2 pages, single-spaced. The estimated liability, if the victim pursued civil damages, was $412,000. I held the phone away from my ear for 3 seconds, not because I was upset, because I was reading the silence between her sentences the way I'd been trained to read the silence between witness testimony and corroborating evidence for 23 years. There was a gap, a structural gap. Someone had coached her on what to say and in what order. The phrasing was too clean for a woman who had never once in her life used the word liability in casual conversation. It's already written up, Catherine. All you have to do is sign. Renee can't afford this. You can. Noted. That was her fourth request this year that assumed my compliance before asking for my consent. I had logged the first 3. Before I lay out what I found and what it cost them when I did, I want to know something. What time is it where you are? I've learned to note the time of things. It matters more than people realize. My hands have a particular habit when something is wrong. They go flat, palms down, fingers spread slightly, pressing whatever surface is closest as though testing for vibration. I have done this on the bench during testimony I knew was false. I have done this in chambers reading affidavits that contradicted physical evidence. I have done this at kitchen tables and in hospital corridors, and once in the parking lot of a middle school where my nephew's enrollment records did not match the address my sister claimed to live at. My hands went flat on the countertop of my own kitchen the night my mother called, and I stood there for 11 seconds before I spoke again. I know it was 11 seconds because the microwave was counting down behind me. I had been heating soup. The microwave reached 0 and beeped, and I still had not moved. I am a judge. I have served on the circuit court for 11 years, and before that I was a prosecutor for 12. I spent my career reading documents the way a structural engineer reads load-bearing walls, looking not at what was presented, but at what was missing, what was dated wrong, what was signed by someone who should not have had access, what was notarized in a jurisdiction that made no sense. That skill had exposed fraud, perjury, and conspiracy across hundreds of cases in rooms where people believed their paperwork was perfect. It was about to do the same thing to my own family. I grew up in a house where everything flowed toward Renee. Not because she demanded it, at least not at first, because my mother had decided before either of us could talk that Renee was the fragile one. Renee was the one who needed softening. Renee was the one whose failures were circumstances, and whose circumstances were everyone else's responsibility to manage. I was the other kind of daughter, the kind who got good grades and was told that proved she didn't need help, the kind who paid for her own bar prep course, while my parents covered Renee's second attempt at cosmetology school. The kind who, at 29, lent Renee $11,000 for a deposit on a salon lease, and was told by my mother not to ask for it back because your sister is finally finding her footing. The first documented incident was in 1996. Renee bounced a rent check using an account my mother had co-signed. My mother covered it and told me at Thanksgiving that I should consider co-signing Renee's next lease, since I had more stability. I was a second-year law student working 30 hours a week at a legal aid clinic. I said no. My mother did not speak to me for 6 weeks. In 2003, Renee's first marriage ended. She moved into my apartment for what was supposed to be 2 months. It became 7. She left owing me $3,200 in shared utilities she had agreed to split, and never paid. When I raised it, my mother told me I was being transactional with family. I was a junior prosecutor pulling 60-hour weeks. I let it go. I should not have let it go. In 2011, I was appointed to the bench. My mother came to the investiture ceremony. She brought Renee, who spent the reception asking my colleagues whether judges got free parking. My mother pulled me aside during the reception and asked if my new salary meant I could help Renee with a down payment. I had been a judge for 4 hours. In 2017, Renee's second husband, Dale, started a contracting business. My mother asked me to co-sign a line of credit for equipment. I declined. She told me I had become cold. Dale's business failed within 14 months. The debt, as I later confirmed, was absorbed by a second mortgage on my mother's house, which Renee had arranged and my mother had signed without reading the terms. I did not learn this until later. I should have looked sooner. The irony is that I had spent 2 decades reading other families' disasters on paper, tracing the exact moment when the person with the resources stopped asking questions because the answers would have cost them their peace. I delivered rulings from the bench about families just like mine. I could see the pattern in a stranger's bank records from across a courtroom. I could not see it through my own kitchen window. By 2024, the pattern had become a system. My mother managed information, Renee consumed resources, Dale provided logistics, and I, the circuit court judge, provided the one thing they could not buy: credibility. My name, my reputation, my spotless record. Every time I helped, every time I signed, every time I wrote a check and asked no questions, I was not being generous. I was being inventoried. The hit and run happened on March 8th. Renee struck a parked car in a grocery store parking lot at approximately 6:15 in the evening. A 17-year-old boy was standing between the parked car and a shopping cart return. He suffered a fractured pelvis and 3 broken ribs. Renee left the scene. A security camera recorded the vehicle, a 2016 silver Nissan Rogue with a dented rear quarter panel. The vehicle was registered to Dale. The plates matched Renee's insurance. And within 72 hours, my family had assembled a plan to transfer criminal and civil liability to me. The statement my mother read to me over the phone claimed that I had borrowed Renee's vehicle that evening to run errands, that I had been driving, that Renee had been home with Dale. I stood in my kitchen and let my palms press flat against the granite. The microwave had beeped, the soup was done, and I was already running numbers I had not asked myself to run. The statement referenced a time of 6:15. On March 8th at 6:15, I was in my chambers finishing a ruling on a custody modification. My clerk, David Alderman, had been in the anteroom. My electronic case management login showed active session timestamps from 5:48 to 7:02 that evening. I had not been anywhere near that grocery store. And whoever prepared the statement had not checked. Then I found something else. The prepared statement my mother read to me was formatted in a way I recognized. Not the content, the formatting. Justified margins, 12-point Georgia font, a double space after the signature block with a notary acknowledgement line that used outdated language, specifically the phrase subscribed and sworn, without the 2019 statutory update to signed and verified. Only someone using a legal template from before 2019 would have that phrasing. I asked my mother to send me the document. She texted a photograph of it the following morning. I examined the photograph on my laptop. The document properties were not visible from a photograph, so I asked her to email the file directly. She did, without hesitation, because she had no reason to think I would examine it the way I examine every document that crosses my bench. ONU9, the file was a Word document. I opened the Properties panel. The author field read Dale Mackey. The creation date was March 9th, the day after the hit and run. The last modified date was March 12th, 2 days before my mother called me. The template used was a legal form downloaded from a commercial document website. I checked the site. The template had been available for purchase at $14.99 and was marketed as a voluntary witness statement form. It had not been reviewed by an attorney. The notary acknowledgement section had been pre-filled and never corrected. That was layer 1. The obvious insult. They had typed up a false confession, formatted it to look legal, and expected me to sign it without reading it. But I had read it, and the author field told me Dale had written it. Then I found something else. I called the grocery store and asked to speak with their loss prevention office. I identified myself by name only, not by title, and requested a copy of the incident report filed on March 8th. The loss prevention manager told me the report had already been requested by a woman identifying herself as the driver's sister on March 10th. The sister had asked whether the footage could be released to family members. She had been told no. She had then asked whether the footage clearly showed the driver's face. She had been told the footage showed the vehicle and the license plate, but not the driver's face, through the windshield due to sun glare. That was the moment they decided the plan could work. Renee had called the store, confirmed the camera could not identify the driver, and reported back. The false statement was created the next day. The plan was not spontaneous. It was researched, designed, and executed across 6 days. I requested the store's footage through a formal records request, citing my capacity as a concerned party. The footage confirmed what the loss prevention manager described: the silver Nissan Rogue, the license plate, the impact, the boy falling, the vehicle accelerating out of the lot. The sun glare obscured the driver's face, but the footage showed something the family had not accounted for. The driver's left hand on the steering wheel was visible, specifically a ring, a wide rose gold band with a square-cut stone. I had seen that ring at every family dinner for 3 years. It was Renee's anniversary ring from Dale. I wear no rings, my hands are bare. I have been photographed on the bench, at public events, and in family photographs with bare hands for over a decade. The ring was a detail only someone who looked at hands for a living would catch. I look at hands. I watch people hold pens. I watch how a witness grips the railing. I watch how a defendant's fingers move when they are about to lie. Before I show you what the third document contained, tell me where you're watching from. I want to know how many people are in the room when the truth finally gets said out loud. Then I found something else. This was not the first time Renee had asked someone else to absorb her consequences. In 2015, Dale had been cited for a code violation on a job site. The fine was $1,800. My mother paid it. The citation was issued to Dale's company, but the check my mother wrote was made out to the municipal court directly, and the memo line read, "For Renee." I found this because I requested my mother's bank statements for the prior 10 years through a financial advisor she had once asked me to recommend, a man named Arthur Peretti, who had kept scrupulous records. Arthur provided the statements without hesitation when I explained what I was examining. The pattern was visible across a decade: 11 separate payments from my mother's accounts to agencies, courts, creditors, and landlords, all connected to Renee or Dale. Total, $61,400. My mother's second mortgage, the one Renee had arranged in 2018, was taken against a home that was nearly paid off. The remaining balance was $94,000. The document I found that afternoon made everything before it irrelevant. Not because it was worse, because it was first. I subpoenaed Renee's insurance records through a colleague in the district attorney's office after learning that the hit-and-run victim's family had filed a police report. The insurance policy on the Nissan Rogue had lapsed 6 weeks before the accident. Renee had been driving uninsured. Dale had canceled the policy to save money after losing a contract. The $412,000 liability estimate my mother had cited was not a worst-case scenario. It was the floor. Without insurance, the full cost of the boy's medical bills, rehabilitation, lost future earnings, and pain and suffering would fall directly on the driver. The false statement was not about protecting Renee from embarrassment. It was about transferring a 6-figure debt to me, a sitting judge, whose salary was public record, whose assets could be attached, whose name on a settlement would guarantee payment. I was the mark. I had always been the mark: the co-signed leases, the unpaid loans, the down payments, the silence at Thanksgiving. Every act of generosity I had mistaken for family was an entry in a ledger I had never been shown. The confrontation took place in my mother's dining room. She had renovated it 2 years earlier with money I now knew came from the second mortgage Renee had arranged. The table seated 10. The chandelier was new. The wainscoting had been painted twice. My mother loved that room. She hosted every holiday in it. She called it the heart of the house. She believed she controlled it. I arrived on a Saturday afternoon. My mother, Renee, and Dale were present. I had asked to discuss the statement. They believed I was coming to sign it. I placed the Word document properties printout on the table. This is the author metadata for the statement you asked me to sign. The author is Dale Mackey. The document was created on March 9th and modified on March 12th. Dale shifted in his seat. Renee looked at my mother. My mother's face did not change. "That doesn't mean anything," Dale said. "I typed it up because Renee asked me to. That's not illegal. You typed a false confession and asked a sitting judge to sign it. Nobody said false." Renee's voice was steady, which meant she had rehearsed. "We just thought it would be simpler. You have better resources, better lawyers. I don't need a lawyer. I didn't hit anyone. My mother placed both hands on the table, palms down, a gesture I recognized because I do the same thing. Catherine, after everything this family has been through, after everything I've done to keep us together, you are going to sit here and act like your sister is a criminal? I'm going to sit here and present evidence. I placed the second printout on the table, the store's loss prevention call log showing Renee's inquiry on March 10th. The request about the camera angle, the confirmation that the driver's face was not visible. Renee called the store 2 days after the accident to confirm the footage wouldn't identify the driver. Then Dale created the statement. This was planned. Renee stood up. You are unbelievable. You have everything. Everything. The title, the salary, the respect. And you can't do this one thing for your family? Sit down, Renee. Don't talk to her like that in my house, my mother said. I placed the third document. Arthur Peretti's summary of 10 years of payments. $61,400, the second mortgage, the lapsed insurance policy. The insurance on the vehicle was canceled 6 weeks before the accident. There is no coverage. The full liability transfers to the driver. You asked me to accept a debt that could exceed $500,000 for an act I did not commit, in a vehicle I have never driven, on an evening when I was logged into my case management system from my chambers. You're twisting everything, Dale said. We were trying to protect the family. You were trying to protect yourselves, with my name. The room was quiet for 4 seconds. Then my mother tried a different approach. She lowered her voice. Catherine, please, if you could just help us find a way to make this go away. I'm not asking you to sign. I'm asking you to help. You read me a prepared statement and told me to sign it. That is exactly what you asked. The doorbell rang. It was Arthur Peretti. I had asked him to come at 3 o'clock, 30 minutes after I arrived. He carried a manila folder containing my mother's complete financial records for the past 10 years, organized by date, annotated by category. He set the folder on the table beside the chandelier my mother had purchased with borrowed money. Arthur looked at my mother and said, quietly, Eleanor, I tried to tell you in 2019 that the second mortgage terms were predatory. You told me Renee had reviewed them. I don't believe Renee reviewed them. I believe Renee arranged them. My mother's hand trembled against the table. Renee did not sit back down. Renee decides that consequences are a resource to be allocated to whoever can best afford them. I did not say anything else. I did not need to. The silence in that dining room lasted longer than any silence I have ever observed from the bench, and I have sat through silences that ended marriages, ended businesses, ended decades of pretending. My mother's gray zone did not resolve that afternoon. She sat in her renovated dining room and said nothing while Arthur placed documents beside her plate. 3 weeks later, she called me, not to apologize, to ask whether the boy's family had filed suit yet. I told her I did not know. She was quiet for a long time. Then she said, I should have read the mortgage papers. That was the closest she came, in that first month, to acknowledging what had happened. It was real. It was also insufficient. I told her I heard her. I did not tell her it was enough. 7 weeks after the confrontation, my mother called again. She had spoken to a financial counselor. She had begun reviewing her accounts. She asked me whether Arthur could help her understand the mortgage terms. I gave her Arthur's number. She did not mention Renee. I did not ask. In the 4th month, she sent me a letter, handwritten, on stationery I recognized from her bedroom desk. She wrote that she had spent 40 years believing that protecting Renee was the same thing as loving her. She wrote that she understood now that she had used me as a supply line and called it family. She asked whether I could forgive her. She did not ask me to forgive Renee. The letter was 3 pages. It was the most honest thing she had ever written to me. I put it in my desk drawer. I have not written back yet. I do not know when I will. The criminal investigation moved forward without my involvement. The police report, combined with the store footage and the lapsed insurance records, was sufficient. Renee was charged with felony hit and run and driving without valid insurance. Dale was questioned regarding the preparation of the false statement, but was not charged. The boy's family filed a civil suit against Renee and Dale jointly. The estimated damages exceeded $500,000. Dale's contracting license was suspended pending resolution of the civil case because the vehicle used was registered to his business. 3 of his remaining clients terminated their contracts within the month after the charge became public record. Renee retained an attorney, using money my mother lent her from savings, not from the second mortgage, which was now under review by the financial counselor. The dining room chandelier was still there the last time I visited my mother, but she had stopped hosting holidays. The table seats 10 and now typically holds 1. Renee has not spoken to me since the confrontation. She called my mother the day after and said I had destroyed the family. My mother, for the first time in my memory, did not repeat this to me as a request to make peace. She repeated it to me as evidence that Renee had not changed. The boy, Marcus Delgado, completed physical therapy in 5 months. His mother sent a statement to the court describing the night of the accident, the call from the hospital, the moment she saw her son on a gurney with his left leg immobilized. I read the statement when it became part of the public record. I sat in my chambers with my palms pressed flat on my desk for a long time. I was not calculating anything. I was just sitting with the weight of what my sister had done to a child and what my family had asked me to cover. I donated anonymously to Marcus Delgado's recovery fund through his family's verified account. The amount was $11,000, the same amount I lent Renee in 1997 and never recovered. I did not tell anyone. The number simply needed to go somewhere it could do something. What I rebuilt was not dramatic, it was ordinary. For 11 years on the bench, I had declined every invitation to teach, to write, to speak at judicial conferences, because my weekends were consumed by family logistics, my mother's finances, Renee's emergencies, Dale's latest crisis. I had postponed a judicial education fellowship twice. The second time, I told the program director I had family obligations. She told me the spot would not be held a third time. In June, 4 months after the confrontation, I applied again. The fellowship was a 6-week program at the National Judicial College. I was accepted. I flew to Reno on a Tuesday morning with 1 suitcase and a laptop, and no voicemails from my mother asking me to call Renee. The silence on my phone was the loudest sound I had heard in years. I am writing this from a desk in a room that contains only my own things. The overhead light is a simple fluorescent bar, not a chandelier. On the desk in front of me is a financial summary Arthur Peretti prepared at my request. It shows the total amount I transferred to family members over 27 years. The number is $414,600. I stared at it for a very long time. It is $2,600 more than the liability figure my mother quoted the night she asked me to sign a false confession. That number means something different now. Not what was taken, what I chose to stop giving. I have spent a career sitting in rooms where the truth arrived late and landed hard. I have watched people present falsified documents with complete confidence. I have watched families collapse across a courtroom when the evidence made denial structurally impossible. What I did not understand until I sat in my own mother's dining room holding my own evidence in my own hands was that the professional skill and the personal blindness can live in the same body for decades without ever meeting. I thought my training made me immune. It made me competent. Those are not the same thing. The silence I maintained at family dinners was the same silence I penalized witnesses for in my courtroom. I knew what silence cost. I chose to pay it in my own house because the alternative was admitting that the system I was raised inside was built on the same structural failures I was appointed to identify. Consequences are not cruelty. They are the weight of choices finally being carried by the person who made them. Every dollar, every forged statement, every unanswered question, every time I wrote a check and called it love, those were load-bearing walls I built for people who were quietly hollowing out the foundation. Removing myself did not collapse the house. It revealed that the house had been unsound for a very long time. When you watched it happen and stayed quiet, what were you protecting? Because it was not them, and it was not yourself. It was the version of the story where no one had to answer for anything, and that version was never going to hold. This story is a fictional narrative created for entertainment, education, and dramatic reflection. We hope it reminded you that your dignity is not negotiable, and that setting a boundary, even a painful one, can be an act of love for yourself and everyone the pattern would have reached next.